Hello, everybody. We would like to welcome you to this session of the BUL International Law Group on the nexus between international law and constitutional law. The Brunel University in London is very pleased and honored to host today three distinguished speakers who are going to speak about parameters of this subject. The first of our speakers is Professor Evangelos Venizelos. Professor Evangelos Venizelos, who has been also Greece's former Deputy Prime Minister and a senior minister in a number of posts, from Minister of Finance to Minister of Foreign Affairs, Minister of Transport, Culture. He has served in the government in all the posts. He was the rapporteur of the parliamentary majority in the amendment of the Greek Constitution in 2001, and he was the chairman of the Greek Socialist Party, PASOK. And today, after he has left his major political role, he is a professor of constitutional law at the Aristotle University of Thessaloniki. We have together with us also Professor Tom Ginsburg from the University of Chicago. Professor Ginsburg is the professor of international and constitutional law at the University of Chicago. And he has a focus on constitutions and on comparative constitutional law. He has a PhD from the University of California at Berkeley. And before joining academia, he was a legal advisor at the Iran-US Tribunal. His latest book, which is going to be the core of his presentation today, is titled Democracies and International Law. Last but not least, we have together with us Associate Professor Yaniv Roznai from Reichman University, the Interdisciplinary Center in Herzliya, Israel. Yaniv Roznai has been a legal advisor in the Knesset, in the Israeli parliament, and today he is an associate professor at the Harry Ratzinger Law School in the Reichman University. He holds a PhD from the London School of Economics. His publications have appeared in a number of venues, including the American Journal of Comparative Law, the International Journal of Constitutional Law, and others. And he has been a visiting professor at the University of Milan in Italy, and in universities in Spain, Turkey, and Emory University in the United States. Apart from this, Yaniv is the author of a very successful book that concerns the constitutional amendments, a book that has been translated already in Spanish and Japanese, and he has been recipient of a number of awards in Israel, most prominently the Knight of Government Quality 2020 award by the Movement of Quality Government in Israel. We welcome the speakers. The event is going to be waged along this session. First of all, although Professor Venizelos should have spoken first, because of Professor Ginsburg having to leave, Professor Ginsburg is now going to speak for about 15 minutes. The 15 minutes will be followed by 5 minutes of a brief discussion between us regarding the sayings of Professor Ginsburg, before we go forth to Professor Venizelos and then to Professor Roznai. In the end, the audience has the ability to ask in written questions in the questions and answers section that you are seeing in your screen. So this is the procedure that is going to be followed, and with no further delays, we welcome Professor Ginsburg, and the microphone is yours.
Thank you so much, Dr. Solomon, and it's an honor, of course, to be with Professor Venizelos, as well as my old friend, Professor Roznai. And, you know, it's a really important topic that we're talking about, the relationship between international law and constitutions. And my latest work that Professor Solomon referred to is called Democracies and International Law. And it kind of grapples with that question. It's obviously a very stark moment for thinking about the role of international law in either requiring democracy or supporting democracy, or actually supporting the backsliding and the degradation of democracy. And I think you could make arguments for all three of those positions. And I think what I'll do is start with a story or slide. Actually, I'll share a slide here, which is a story about two elections. Oh, that's the wrong one. That's a paper of mine. Forgive me. Shouldn't have tried to do the slide, my bad. A story of two elections that occurred in the year 2016. Now it's just not working. And these elections occurred in West Africa. One was in the Gambia. The Gambia is a very small country in West Africa surrounded by Senegal. And it was ruled at that time by a dictator who had been there for 20-something years after having taken power in a coup. And of course, like many dictators, he had elections. Elections function very differently in authoritarian countries than in democratic ones, but there's good reasons to have elections. And one of those reasons is that international law seems to require them. The International Covenant of Civil and Political Rights, for example, states that everyone has the right to participate in elections periodically to select their rulers, and everyone has the right to participate in government. So those seem to be pro-democratic provisions of international law. But as this president, Yahya Jammeh, illustrated, as in many other countries, we see the abuse of those provisions. So they would have elections, but they weren't truly competitive, and there were many techniques for repressing the other side. Something funny happened in 2016. To his great surprise, the opposition banded together and the opposition candidate won. And Jammeh then said, you're right, I'll honor the election. But he did something very dumb thereafter, which is after saying he would honor it, he changed his mind. And that led to an intervention by the regional organization, ECOWAS, the Economic Community of West African States, which, mobilized an army on his borders. And, eventually in the face of that, he left the country. This seems to be a pro-democratic intervention for the integrity of elections, and that grounded in international law, at least one vision of international law. Where did Jammeh go? Well, he went to a country called Equatorial Guinea, a neighboring country, which was run, or is run to this day, by a man named Teodoro Obiang, who has ruled that country for 30-something years after taking power from his own uncle in a military coup, and also has elections, wins regularly by 80%, and there was no ECOWAS intervention. There's repression of the opposition. It's not a democratic country. International lawyers will know this country from the famous case against France involving diplomatic immunities. Was his son and so-called vice president, who had, hundreds of millions of dollars in France of stolen money, were those assets immune from attachment or not, or were they diplomatic? In any case, international law seems to have schizophrenic answers. And this is the basic dilemma we face. On the one hand, international law requires territorial integrity, self-determination, non-interference by outside powers in Article 2.4 of the United Nations Charter. On the other hand, we have norms in the International Covenant of Civil and Political Rights, which seem to be pro-democratic and require certain democratic institutions as a universal matter. Now, at one time, there was an argument that this meant international law required democratic governance. There was an international right to democracy. And this was a position put forward in 1992 by Thomas Frank. And it's not one that I agree with, honestly. It would be nice if every country in the world was democratic and international law could do something about that. But as an empirical matter, I don't think from my study of democracy that it is a possible form of government for every country in the world. It requires certain levels of wealth and education to function. And if you require international law to essentially turn every country into a democracy, you're going to have a lot of conflict. You're going to have a lot of things like the Iraq invasion, even though that was illegal, but military interventions, which create more conflict. It's a very old critique of liberalism generally, that liberalism creates conflict by insisting that it expand its own domain. Now, that if international law is not a right, not required, if democracy is not a right in international law, then what is the relationship? And here my book takes a very empirical approach. And one of the things I show with lots of evidence in all kinds of areas is that democracies are the states, the kind of countries that use international law the most, that have the most deep cooperation with each other, and that benefit the most from international law. Think about the European Union, a very deep and sophisticated regulatory enterprise. And I know it's controversial in some countries in certain provisions, but let's face it, it's a kind of cooperation that is one that would not be possible at that deep level among authoritarian regimes. We see similar attempts among authoritarians. The United Arab Republic, for example, in the Middle East, which failed twice. The Eurasian Economic Union, which is a body that mimics the European Union, centered around Russia, and other Russia-centered international organizations, but they do not have the same level of deep cooperation. They're mostly devices for Russian domination of those neighbors, and they serve the Russian interest primarily. And so you go down the list and you see, well, democracies make more treaties with each other. They tend to go to court much more often. A very large percentage of the court cases or arbitrations brought under a very technical area of law, like the law of the sea, for example, doesn't seem to have a pro-democratic or pro-authoritarian, leaning. Nevertheless, overwhelmingly, something like 19 out of 21 states at the Hamburg Tribunal are brought by democracies or citizens of democracies. The same is true in investment law, in trade law, and so on. So that suggests that democracies are benefiting from international, and I think we have a kind of a reason we would think that's the case, that because governments and democracies have longer time horizons than their own survival, they might be willing to cooperate with each other to do things which are in the long-term interest of the country and not worry about just its effect on their very narrow political survival, since they will be gone at some point anyway. Democracy is defined by the fact that today's government will not be there at some future date, and that they won't be punished too badly when they do go. So I think this time horizons is kind of an explanation for it. I won't go into the full theory. But the point is that we see a lot of cooperation among democracies, including sometimes to defend democracy at the regional level, as in the ECOWAS story. And I think when you look at the evidence, you see that that's really important. These regional organizations turned out to be extremely important. And I think they have done a good job. And I would include the European Union, the Council of Europe, notwithstanding lots of complaints about Poland and Hungary and how slow those organizations move. The Organization of American States, which in my view saved Honduras democracy very recently. And several organizations in Africa, which I think have led, even though there's been a lot of coups in Africa in the last year, I think those coups are much less harmful in terms of the loss of life and the violence than they would have been otherwise. And each coup leader, for the most part, says that they'll soon return power to civilians. So in any case, I think pro-democratic governance is possible. And in this way, the international law can support domestic institutions. Now, there's another trend which I have to mention, which is what I call authoritarian international law. This is the idea that, generally speaking, as I was talking about before, authoritarians do have institutions which look like those of democracies. They have elections, they have courts, they have constitutions, they have long lists of rights. Those institutions play a very different role for an authoritarian than for a democratic government. And one of the recent trends I've identified is that now authoritarians are using international law in just the same way. And they're using it to cooperate with each other, and they're making up new rules of international law, changing international law, repurposing it, not to facilitate democratic government, but to preserve their own authoritarian governments. And I have many examples, but one might think of something like the Shanghai Cooperation Organization, in which the members, which are primarily authoritarian governments in Central Asia, Russia, and China, agree to extradite each other's dissidents across borders. And they agree that they will all punish something called separatism or extremism, whatever that is, as well as terrorism. And so there's this kind of authoritarian cooperation on repression. but it's a thinner cooperation. It doesn't extend in the very deep ways that we see among democracies. And, you know, I think that it's important to name that, particularly in the context of the Ukraine conflict, to recognize that authoritarian international is often changing its arguments, but they are legalistic in nature. Vladimir Putin, and I'm sure Professor Venizelos will talk a little more about these things, but, you know, in the Ukraine invasion is couched in legalistic terms and reflects a kind of abuse of international law. And I'll just say one more thing about that and then wrap up. What was Putin's international law strategy for Ukraine? Well, it involved, first of all, abusing the norms of self-determination. Just as he has earlier carved up Georgia and taken part of Ukraine, he has done so in the name of self-determination. It involves, first of all, sending Russian passports to nationals of another country and saying, okay, now you're Russians, which means we have an international right to protect you. Not only do we have an international right to protect you, you have an international right of self-determination to choose to join us. And this isn't really the conventional view of self-determination. I don't think it's legal, but you see how it's an abuse of that term in a way that what does it really lead to? The expansion of Russian territory and Russian puppet states. So this is what I mean by authoritarian international. It's a grave challenge for democracies. And what do we have to do about it? Well, I have a lot of thoughts on that, but I do think recognizing that international law shapes domestic constitutional structure and matters a lot for it means that we have to not ignore it. Here in the United States, Americans don't like to think much about international. We're very parochial, and that is a very, very bad mistake. We've made the last administration terrible mistakes in terms of not only not fighting for democracy, but siding with authoritarians. And that damage has to be undone ultimately by us, but hopefully with the help of other countries. Well, I've spoken for my allotted period, so I think I'll stop here. I have much more to say, but I really appreciate the opportunity to share these ideas from the book, Democracies and International Law.
Thank you very much, Professor Ginsburg, for this eloquent statement about the role democracies can play in international law. I would like to ask Professors Venizelos and Roznai about their thoughts and initial comment, if they have. Professor Venizelos.
First of all, thank you very much, Professor Ginsburg, for this excellent presentation. Your book is indeed impressive because your conception concerning the international law is a conception of values, not a technical one. And I share absolutely and without hesitation your approach. But after the fact of the Russian military invasion in Ukraine and the start of a new global war in Ukraine, the question is if we need a democratic international law or a global international law of coexistence on the common denominator of some fundamental common acceptances between democratic and authoritarian regimes. Because as you understand, Russia as an authoritarian state, but also as a permanent member of the Security Council of the UN, has the possibility to block the total UN system, the international legal system as a whole. On the other hand, the main statement made by President Biden in order to legitimate the withdrawal from Afghanistan is that democracy, it's not a product for exportation. Maybe not only democracy, but also the rule of law. From this point of view, and in this new era for the mankind, is absolutely important, vital. This is my approach to organize a new frame of reference for the coexistence between democratic and authoritarian regime, because we need a legal order in position to be Biden for the authoritarian regimes. This is my main remark.
Thank you very much, Professor Venizelos. Professor Ginsburg, anything you want to comment about?
Well, I agree completely. And I actually think the Ukraine invasion shows us that, some people, some politicians are saying this is basically about the fight between democracy and dictatorship. But that's not quite right, because 141 members of the United Nations voted with the Ukraine against the Russian invasion, including many dictatorships, including some neighbors of Russia, including some members of the Russian CSTO. So that means that all states, doesn't matter your form of government, have an interest in these fundamental norms of Article 2.4 of, self-determination, non-interference. And they see this invasion, they say, God, are we going to be next? And so I think there is a basis actually for that kind of framework you're articulating. I agree, but your point that Russia can block the whole UN system might mean that we really have to sort of start over. I think the possibilities are there though, so therefore I agree with you.
Thank you very much, Professor Roznai.
Thank you very much, Professor Ginsburg, for this wonderful presentation. Just maybe two questions rather than comments. One question is about the theory, because prima facie, we can imagine, in democracies, the politicians want to be re-elected. So they have this incentive to do short-sighted or short interest actions. And in contrast, it is those authoritarians who don't really care or not supposed to care what the people want, and they can do things that are good for the country in the long term. So it's kind of counter what you said. So I'm curious about that. The second question, if I may, is since we have many more countries that are not full democracies, one would have expected to see customary international law developing in that way. So the creation of undemocratic international law with the years. And as this happened, I'm just out of curiosity.
So let me talk about the theory and then why we don't see a general sort of development of all international law being super authoritarian. So in terms of the theory, there are two ways in which democracies and dictatorships are different, or at least two ways. One is the size of the coalition. In a democracy, it could be that, the median voter, the ordinary person, is actually, someone who would be benefited by the policies of the government. The common feature of authoritarian regimes is that's not the case. The winning group is a subset. And it could be a very large group. Chinese Communist Party is 90 million people. And China's a somewhat unusual case because they do have a political theory of authoritarians acting in the interests of the people. That's about 3,000 years old. So that might be maybe set that particular case aside. But for, Obiang, the size of the winning coalition is him and his family, and they take most of the money from Equatorial Guinea's oil. And that's a very typical situation, as I think we all know. Now, that means their time horizons are different and their size of distribution. The public goods that they want for their country are things that are going to benefit them, not necessarily the people. And that's a smaller set of things, set of things. They actually don't want a vital private economy because that could create challengers for them. They don't want, necessarily to waste money, spend money on healthcare and things like that. And Equatorial Guinea has some of the worst development indicators in sub-Saharan Africa, even though it's the richest country in per capita terms. So they don't care about the public. The other thing is that their time horizons are only them and their family. And that could be a long time. If you think of a monarchy, the Saudis would like to last for a while. But they are very afraid of losing power to someone else in their inner circle. Obiang bumped off his own uncle. He's worried about someone in his group bumping him off. It shortens the time horizon. In a democracy, the one thing the government knows is that it's going to be out of power. And that creates an incentive to tie the hands of future governments by making international legal commitments. If we, really want to produce a public good for the people that will get us reelected, and we're worried that we're going to lose power, you do an international agreement and you lock in that policy at the international level. It could be environmental protection, it could be a bigger market, security, and you make sure that the next government can't reverse the policy. That way your policies survive your own political life. And that's the key difference. Authoritarians don't care generally about policies surviving their political life. So that's the theory. And now, in terms of authoritarians, you're right, like most governments are authoritarian. In the period I study, which is from World War II to today, about 40% of country years in that period were were democratic. So democracy is a rare condition, even though right now, the last 30 years, it's been at a relative high and now is declining rapidly, as we all know. So, but the thing is, not all law made by democracies is pro-democratic, right? I talked about the law of the sea. Trade agreements don't really matter in terms of their democratic quality. Both kinds of governments will want those. So I distinguish between pro-democratic international law, things like the ECOWAS invasion or a democracy charter or something, or human rights, general international law, which all states need, law of the sea, etc., and then authoritarian international law, which is specifically designed for authoritarians. And the biggest category, of course, is the one in the middle. And that's the one where democracies just seem to do all of the work. They participate in the meetings, they conclude the treaties, and they adjudicate the cases. So there's something about general international law, the kind of framework Professor Venizelos was talking about, a framework for mutual accommodation, which still would be good for democracies and citizens of democracies, because they tend to care more about these things. And it's the reason that this authoritarian international has emerged only, well, I mean, you could go back, I suppose, to the Congress of Vienna, for something like that. But, it's really quite sophisticated, becoming quite sophisticated now, because we have two large players, China and Russia, which have a lot of international lawyers and think carefully about how to advance their interests by diluting the pro-democratic norms. Human rights with Chinese characteristics is a famous phrase. Democracy with Chinese characteristics. Well, democracy with Chinese characteristics is one of two things. Either it doesn't exist or it's in Taiwan. So it's not, it's an abuse of those terms. And that's exactly why I think democracies have to care about all of this stuff. We can't just, hope it's going to emerge on its own.
With your permission, Dr. Solomon, on a practical level now, there are sanctions from democratic countries. We have a kind of Western way sanctions against Russia without the participation of authoritarian regimes. And on the other hand, the main issue is the criminal jurisdiction. If the so-called authoritarian hemisphere of the international community, of the international legal order, is ready to accept the jurisdiction of the International Criminal Court for Russia, for President Putin himself. This is the problem. And this is the practical distinction between the so-called democratic approach and the authoritarian approach of the international legal order as international rule of law, because this is the main question, to organize the international rule of law.
If I can say something on this, Professor Ginsburg, and then maybe you can comment holistically on all the thoughts. I would like also to speak about the International Criminal Court, and Professor Venizelos predated me here, about the issue we spoke about democracies, how they engage with international bodies. But what about the International Criminal Court? There we see democracies going away from the criminal court. And not only this, the United States. A second question is, what about the United States as a democracy, which albeit keeps a very isolationist position towards international law, in the law of the sea, international criminal law, regarding the Organization of American States. So maybe the US is an exception to the dogma you presented.
Yes, maybe I'll just say a word about the International Criminal Court, about the United States, and then respond to a couple of the questions in the chat. Yes, I don't see the International Criminal Court as an essential feature of democratic governments. And, it's nice, it would be great if all states agreed to it. But it's a relatively new phenomenon, and it's directed, of course, at conflict, whether created by the West or, a democratic country or an authoritarian country. So I think it's kind of general international law. And indeed, one reason the United States hasn't signed is precisely because of a point that's raised in the chat, that we ourselves sometimes are engaged in very, undemocratic actions overseas, and don't want our hands tied and potential liability for our leaders or our military for those actions. One of the points I make in the book is just because democracies are cooperating on some matter of international law does not mean that that thing they produce is itself democratic. Indeed, you might think that democracies may be more inclined to outsource certain things which they cannot do at home. And I think two examples might be, Israeli occupation of the West Bank, and the legal status of that, or the American naval base at Guantanamo, which of course is now 20 years old, and we have 30-something men who've been held without even being accused of a crime. And that's a fundamentally undemocratic action that wouldn't happen if they were in the United States. So we kind of put it over there so we can outsource it. So I think that's quite, that we shouldn't think that what democracies do is automatically better in terms of international law. All I say is that it's good for the citizens of democracies. That's my limited claim. If I might answer a question in the chat, I see a question. I'm very glad that we have someone from the Russian Federation, Nikita, here, because I think it's obviously very important that we all be talking. And I'm myself quite disturbed by some of the extremes of the, where conflict at the political level is sometimes being taken out on individual, students and things like this. We have to fight that. There is, of course, something different that is happening now in terms of the international law with the Russian invasion of Ukraine, from all the instances that you cite in the chat, or most of them. This is very much like Saddam Hussein's invasion of Kuwait in 1990, which is an effort to eliminate an independent country. We have plenty of evidence from President Putin's statements that that is a purpose. And that is a fundamental violation of Article 2.4. Now, there are many other violations of Article 2.4, Morocco in the Western Sahara, the Israeli occupation of the West Bank, we could argue about that, Turkey's invasion of Cyprus. Most of these things, though, are not done to actually eliminate an existing recognized state. And so this is a different line. Now, that is not to, in any way, excuse various Western hypocrisies on matters of democracy. My God, I'm the first to do so, as my comment about Guantanamo just suggested. But it is also to suggest that just because other countries have done bad things, that this is somehow okay is not really an acceptable solution or acceptable position, in my view. If we're going to have a workable international law, and a workable international law has to deal with the fact that different countries have different systems. Iran is an Islamic republic, that's okay. Russia is whatever you want to call Russia. But countries get to determine their own political system within certain outer boundaries, that you can't have a genocide or something like that. And, that's the only way that we can live together and work together with Russia and China and all these other countries. And I think it's possible, but you certainly can't have, in that kind of framework, a unilateral decision to eliminate another country as an independent state. That's my position. But
thank you very much, Professor Ginsburg. With this, we can proceed to Professor Venizelos' statement. So Professor Ginsburg, we have the opportunity also to hear Professor Venizelos' work. And Professor Venizelos, the podium is yours.
Dr. Solomon, first of all, thank you very much for your kind invitation and for this excellent opportunity to discuss with you and with Professor Ginsburg and Professor Roznai. We are fellow citizens of Thessaloniki. You are a graduate of our common alma mater studiorum, the University of Thessaloniki, the law school, and I express my proudness for your academic position in the United Kingdom. My specific topic is the impact of the war in Ukraine on the relationship between international and constitutional law. And after this excellent introduction made by Professor Ginsburg, my position is much easier. The war in Ukraine is testing the most classic chapter of international law, the law of armed conflict. You, Dr. Solomon, you are a specialist on this chapter of the international law. It also testing the phenomenon of constitutionalization of international law itself, since the very implementation of the UN Charter is obstructed due to the fact that one of the permanent members of the Security Council is an international law breacher. In practice, this leads the most critical body of the international legal order to a standstill. In reality, it calls into question the entire UN system, including the system of protection of human rights with jus cogens rules applicable erga omnes. The attempt to substitute the Security Council with the Democratic General Assembly under the scheme of United for Peace resolution and excluding the Russian Federation from the Human Rights Council are significant moves. Yet, no legal basis has been formulated in order to impose sanctions on Russia by a UN resolution. We have European decision and American decision, but not a UN resolution. We are also waiting with great anticipation to see, I repeat my remark, if the International Criminal Court shall be able to exercise its jurisdiction in practice in order to punish manifest and barbaric war crimes committed on the territory of Ukraine. In the absence of state and sovereignty, the fundamental element of statehood, international constitutionalism appears dramatically incomplete under armed conflict conditions for which a permanent member of the Security Council is responsible. Yet, there is no doubt that modern constitutionalism as a wave of recognizing and protecting novel human rights in a good number of subjects, climate crisis, bioethics, personal data protection, protection against artificial intelligence, etc., no longer starts from national constitution, but from international organization and international law, which as international human rights law is undoubtedly international constitutional law. Certainly, such is the nature of the European Convention of Human Rights and the EU Charter of Fundamental Rights, because I am a European continental lawyer. Then again, the national state and its sovereignty play a decisive role. The Russian Federation withdrawal from the Council of Europe releases it from the obligation to respect the European Convention on Human Rights and from judicial review exercised by the European Court of Human Rights through the so-called individual application. This development is presented as a sanction against Russia. Russia itself perceives it as an absolute prevailing of the legal supremacy monopoly of its national constitution, which ceases to be subject to review by the Strasbourg Court. We have two different and antinomic narratives. For Russian citizens and all individuals subject to the Russian state's authority in areas under its actual control in Crimea or Donbass, judicial protection, the constitutional protection, in essence, protection of their fundamental rights is radically reduced. Following the military failure of the initial Russian plan for total occupation of Ukraine and replacement of the legal Ukrainian government by one controlled by Russia, discussion, even diplomatic negotiation under the auspices of Turkey or Israel have started under the pressure of armed attacks and war crimes in order for a solution to be agreed. However, in the Russia view, such solution includes agreeing to the secession of major parts of the Ukrainian territory and incorporating the prohibition of joining NATO and Ukraine's military neutrality in its national constitution. What the Russian side proposes is a form of internationalization of Ukraine's national constitution through concluding, possibly under international guarantees, an international agreement which shall be forced by the outside and shall prevail over the national procedure for amending the national constitution. The international agreement shall prevail over the national constitution, and the national constitution shall be accepting the supremacy of the international settlement, which in effect is a settlement based on the military correlation of powers. Of course, this is an old known phenomenon. It was applied, Professor Roznai and Professor Ginsburg know very well, in an extreme fashion to Japan after the Second World War, to Cyprus with the famous treaties of Zurich and London in 1960, in the case of Bosnia and Herzegovina after the war in Yugoslavia with the Treaty of Dayton, in a more elegant manner by the Treaty of Prespa on the name of North Macedonia, the Treaty of Prespa between Greece and North Macedonia. In any case, all countries participating in regional integrations, such as the European Union or regional organization with a judicial review system, such as the Council of Europe, or even in the UN system only, are subject to substantial international restriction in exercising their constituent or amendment authority. They are subject to the political influence and soft legal review of global constitutionalism with, this is the more famous example, the Venice Commission's report as characteristic case. Nonetheless, they are also subject to international judicial review of the way in which they exercise the so-called derivative constituent power in revising the national constitution, and such constitutional amendment is judicially reviewed by the European Court of Human Rights and the Court of Justice of the European Union on the basis of the European Convention or EU primary law, EU values, and the common constitutional traditions of EU member states. Today, due to the war in Ukraine, Poland and Hungary, the two EU member states that are systematic violators of the principle and guarantees of the rule of law, which consist in a broad band of principles, guarantees, rules, and standards, are divided. The Polish government clearly follows the European and Western mainstream. Hungary is not hiding its pro-Russian disposition and leaking for the Russian view. This kind of political choices and conflicts are legally translated into questioning the distribution of competencies between the EU and the member states. This review, known as ultra vires review, is usually accompanied by invoking the protection of the so-called national constitutional identity, not as a European law concept, according to the Article 4 of the Treaty for the European Union, but as the national, supreme, or constitutional courts understand it on the basis of national criteria. But its case law, the Court of Justice of the European Union confirms that EU bodies exercise conferred powers. This is not just a conflict over supremacy, but also as regards the boundaries of the EU legal order domain. Yet, this is a question of interpretation and application of the multinational international treaties, Treaty on the European Union and Treaty on the Faction of the European Union, which form the legal foundation of the EU legal order and delimit it with reference to the legal orders of the member states. This issue can't be resolved neither in the field of the EU nor in that of its national legal order. It is set in the field of the international legal order and can be resolved by the mechanism of international law on the interpretation and implementation of international treaties. However, in the field of the international legal order, states are not represented by their national courts, even the Supreme or the Constitutional Court, but by the political organs which are authorized by the Constitution to represent the country internationally. Thus, oddly, in the critical field of constitutionalization of European law and its conflict with the national constitutions of the member states, the solution must be sought in the classic domains of international law and for the international legal order. The constant alternation, this switching of legal orders, is rationalized by two mechanisms, in my opinion. The first is that of interpretative monism among international, European, and constitutional law. The rules of interpretation of international law and the protection of human rights, mainly the European Convention of Human Rights, are transferred in the field of the EU law through the Charter, and ultimately in the field of the national constitution via the latest interpretation in accordance with the European Convention of Human Rights and the EU law. The second mechanism is not the concept, but the project of the so-called augmented constitution. The national constitution is undergoing a constant relativization through the evolution of the EU law and the international protection of human rights, mainly by way of the European Convention of Human Rights. Nonetheless, such relativization may be converted into an augmentation of the normative guaranteeing content of the national constitution by means of interpretative monism, the national constitution interpretation in accordance with international law and EU law. The objective in each time to opt for the solution which strengthens the protection of democracy, the rule of law, and human rights. The augmented constitution ensures the maximum possible content of liberal democracy, which is the actual war field in Ukraine. Liberal democracy, as normative subject of the augmented constitution, is the West through territory of history and values, Ukraine's deeper territory. Thank you.
Thank you very much, Professor Venizelos, for these thoughts about Ukraine and about the augmented constitution, which is very indeed useful. I will ask Professor Ginsburg before he leaves. I hope he's still with us. I see we have no image of him, but I hope Professor Ginsburg is still with us. If yes, you can comment. And before we bid you farewell, if not, as it is being assumed by your silence, maybe Professor Roznai, you want to take precedence and you want to share any thoughts, and if you have any comments for Professor Venizelos' presentation.
Yes, maybe just one question. Thank you very much, Professor Venizelos, for this great talk. Just out of curiosity, just before the invasion, all of us scholars, we talked about democratic erosion, the crisis of democracy, etc. For the last 15 years, we've seen a constant decline in democracies. And it seems that this invasion actually managed to erode some kind of deeper democratic sentiment within surrounding countries. And you mentioned Hungary and Poland, for example. So do you think this devastating event for world peace can actually be some kind of a cure to the democratic crisis that we've seen in the longer term?
Your remark is absolutely correct. I totally agree. This is a stress test for the Western democracy. We need a strategic reconstruction of the West as entity, and only under the pressure of the conjuncture, only under the pressure of the nuclear threat, only under the pressure of the American administration toward the European governments, we have the possibility to reconstruct the Western as value and also a strategic entity. this is a legal matter, but also a military and practical matter. From this point of view, yes, we have a kind of revitalization of democracy and rule of law through the historical shock of the war in Ukraine, because the war in Ukraine is a double one, a local war between Russia and Ukraine, and a global one between Russia and the West, a proxy war. The one part participates immediately, directly, the Russian party. The other one participates through a representative. And from this point of view, this is my approach, is absolutely impossible to give an end in this war, because the obvious war is the easy part of the problem. The hide war is the big issue. And from this point of view, we need also new legal instruments in order to reorganize the international system, the international legal order, the international system, and to protect the international system as legal order without the UN, because the UN system is absolutely absent.
Thank you very much, Professor Venizelos. I also have a question about the augmented constitutionalism that you mentioned before. You mentioned the example, for example, in Europe, we have the European Convention on Human Rights, and how the EU states can absorb also in the constitutions the values set by the European Court of Human Rights. My question is how the augmented constitutionalism can be enforced in other regions of the planet. For example, Australia, where we don't have peripheral judicial courts. There, for example, in the case of Australia, we have the jurisdiction of the Human Rights Committee, but it's a quasi-judicial body, not a judicial body. So augmented constitutional, yeah.
Without doubt, the concept of augmented constitution is a European one. But on the other hand, I prefer to start with the example, the case of United Kingdom. In the British legal orders, we have this augmentation through the European Convention of Human Rights, even through the last jurisprudence, the last British jurisprudence after the referendum for the Brexit. The famous law cases of Miller 1 and Cherry Miller 2 projects a new concept about the British Constitution itself, a kind of incorporation of rules and also of constitutional convention, a totally different approach about the so-called constitution. In Australia or in New Zealand, we have the UN system, and also we have very important transplants from the European legal tradition. We have very important transplants from the jurisprudence, the European jurisprudence, and also from the case law of the European Court of Human Rights, or from different Supreme Courts. For example, during the pandemic, the Center of Academic Reference for the New Developments in Europe is installed in Sydney, in Australia, because this is a global dialogue and interconnection between the different legal systems and legal traditions.
Thank you very much, Professor Venizelos. And indeed, this shows the universality of law sometimes and the interrelation of the different jurisdictions. Although my point was also about the quasi-judicial bodies, because in Australia we have the jurisdiction of the UN system, but it's quasi-judicial bodies. The Human Rights Committee is not a judicial body. So my question on this is, this will erode the
on the field of both the constitutional law and the international law. The interconnection between the so-called political approach and the legal approach, the political organs and the legal organs, the judiciary, is perpetual. This is a kind of perpetual exchange between the two approaches. This is a very good question for the debate about the best system of judicial review not only on the domestic, but also on the international level. Maybe the problem is Australian or New Zealand, not a European or an American one. The question is absolutely comparable with the question of the constitutional identity of Israel. Maybe the rule is the rule and the exception is the exception. This is my first answer.
Thank you very much. This is very clear. And with this, we're going to go to Professor Roznai's statement. Just to remind the audience, you can send better your questions to the Q&A section that you see here on your screen, rather than in the chat. Professor Roznai, the podium is yours for your statement.
Thank you very much, Professor Solomon. Professor Solomon and I met about 15 years ago in the Israeli parliament, so I'm very happy to see you again. I'm honored to be in this panel together with Professor Venizelos and Ginsburg. So in my discussion, I want to talk about this battle between international law, supranational law, and the domestic constitution, and basically ask the question, can international law limit constitutional change? So the answer to this question, obviously, is from which perspective am I asking this question? Because from the perspective of international law, supranational law, it's quite obvious that international law is supreme. If you take the approach of Kelsen or his student Joseph Kuntz, right, above the pyramid of norms, the domestic pyramid of norms, there's international law. So obviously international law would also limit constitutional amendments or even a new constitution for that matter, from the perspective of international. And the Vienna Convention on Law of Treaties from '69 states exactly this in Article 27, that a party may not invoke the provision of its law, of its internal law, as a justification of its failure to perform a treaty. So from the perspective of international, it doesn't matter whether internal law is the constitution or ordinary legislation or secondary legislation. Domestic internal law cannot be an excuse and not to perform in an international treaty. And this was also verified by various decisions by supranational and international courts. For example, I'll just give one example: the advisory opinion of the Permanent Court of International Justice, the one that preceded the ICJ, on the case of the Polish nationals. So the opinion states, a state cannot adduce as against another state its own constitution with a view to evading obligations incumbent upon it under international law. So it is quite clear that from the perspective of international law, even against the constitution, international law prevails. It's quite clear. And the same goes, as we've just heard, the same goes with supranational regional law. So from the 1970s, the European Court of Justice has held that EU law takes precedence over any conflicting domestic law, including the constitution, first in a case against Germany. And likewise, the various tribunals of human rights. So the European Court of Human Rights, in various decisions, has held that certain constitutional provisions violate the European Convention on Human Rights and have to be modified. So the European Court tells the countries, you need to modify your constitution. I'll just give two examples. 2009, Seji versus Bosnia, there was a constitutional provision that limited the right to be elected. And the court says this is a breach of the European Convention on Human Rights. You have to amend your constitution. Or the 2013 Anchugov versus Russia case on the right to vote. So the constitution prevented the right to vote from prisoners. And the court says, no, this is a violation of the convention. This constitutional provision is unconventional in a way, and you have to change it. And obviously, according to Article 46 of the convention, these decisions are binding, and the courts have to change the constitution accordingly. And this is not only a European thing. If you look at the Inter-American Court of Human Rights, for example, in two cases, one Petruzzi versus Peru, regarding constitutional limitations that limited the right to access to court, the court says this is unconventional. In another case, Olmedo Buzos versus Chile, there was a constitutional censorship of film that was in the constitution, and the court says, no, this is unconventional. You have to change the constitution. And the same in Africa, the African Court for People on National Rights. In the Mitikila case versus Republic of Tanzania, there was a prohibition on the right of independent candidate to be elected. And the court says that this violates conventional rights and the constitution has to be amended. So prima facie, from the perspective of international, the answer, of course, is yes. Yes, international limits even what Professor Venizelos called the derived constituent power, right? The right to change the constitution. But what is the problem? The problem is that international and external validity do not always coincide. Okay, so for example, I'll give two famous examples. One of them is the South African Constitution of 1983. In 1984, the Security Council in its resolution 554 declared that this new constitution that basically entrenched apartheid, the Security Council declared that it strongly rejects this new constitution and declares it null and void. So the Security Council declares the new constitution as unconstitutional in a way. It is null and void. And but what happened to that constitution? It remained in force. It remained in force for about a decade. So basically at the same time, South Africa had two constitutions, one valid constitution domestically and one invalid constitution from an international law perspective. And going back to Sedgwick case versus Bosnia or Anchugo versus Russia. So in these two cases, the European Court said that these various constitutional provisions are unconventional. So what? These provisions remained in force, domestically speaking. So we had at the same time, simultaneously, unconventional constitutional provisions, but still valid constitutional provisions. Not only that, but in Russia in 2015, they amended the constitution in a way that gave the court the power to declare impossible to implement judgments of European rights bodies, basically the European Court, yes, and this what happens. This thing reminds me of this joke, you probably know this joke, Solon, about a rabbi. A husband goes to a rabbi and tells him that he had a fight with a woman, with his wife, and the rabbi hears the story and tells him, you are right. And then the wife goes to the rabbi and tells him, well, I had a fight with my husband, and she tells him the story, and he listens and tells her, you know what, you are right. And then the rabbi goes back to his chamber and his assistant tells him, but rabbi, you told both the husband and the wife that they are right. How is it possible? That's impossible. And the rabbi listens and tells him, you are right. So the same here, at the same time, we have provisions that are constitutional and unconstitutional or valid and invalid in the same time. So it's all a matter of perspective. But this entire story I told you in the last 4 minutes or so, 5 minutes, only engages in the perspective of either international or the domestic constitution. But what is the role of the national courts? I haven't spoken about that. And here the national courts have an important role because they can play or act as agents of international legal orders. There's a famous theory of Georges Sells, the doublement fonctionnel. So the domestic judges basically have some kind of a dual commitment. On the one hand, they are agents of the state, so they have a commitment to abide by the domestic law. But on the other hand, as agents of the state, they also have the authority, the obligations to abide by international law. They have a dual function here. So the problem of this dual function is, or mixed loyalties, what happens when there's a conflict between international and the constitution? Here, the mixed loyalties are at the highest conflict. Because if you're a judge, what will you obey? Will you comply with international or the domestic constitution? Nowadays, especially nowadays, where international law and international institutions are in decline, Brexit, South Africa and the ICC, US and the Paris Agreement, etc., it seems very unlikely that a domestic or a national judge will opt for the international law rather than the domestic constitution. Basically, also, this is part of the populist movement that we're seeing, because populism regards international as a foreign, elitist, and anti-democratic project that must be rejected. And this includes attack on international tribunals. So it may also affect the willingness of the national courts or the national judge to apply international law vis-a-vis the domestic constitution. What we do see, and this is a recent trend, what we do see is recent case law by national courts, according to which international human rights law was used by the national courts to override the domestic constitution. Now, prima facie, this might seem like a great success for international, but a deeper look actually reveals that this is in fact misuse of international law, as Professor Ginsburg just stated. And I'll give you two examples. One example is from Honduras. So the Honduran constitution included presidential term limits. You cannot, the president can only serve one term, 4 years, and then that's it. Not only that, but this presidential term limit was protected by an eternity clause. You can't even change this provision. And even if you only attempt to change it, you're automatically out of office. So when President Zelaya in 2009 tried to amend the constitution in a referendum, automatically it was out of office. So what happened in 2012, the Supreme Court, the Constitutional Chamber of the Supreme Court was captured by the government. And in 2015, what happened was that supporters of the president, of Juan Orlando Hernandez, they actually challenged this provision before the court. And what the court said in 2015, this is amazing, that the presidential term limits that are included in the original constitution violate international human rights law, the right to be elected and the right to vote, and accordingly, they should not be applied. So this is amazing. The national court does not apply the domestic constitution due to international human rights law. But this wasn't really applying international law. This was misusing or abusing international law in order to allow the incumbent president to stand for re-election. And we had the same thing, exactly the same thing in Nicaragua. But I won't go deep to the Nicaraguan case because I don't have much time. So my third point is that eventually what we see is a domestic superiority of the national constitution. As we know, modern constitutions increasingly refer to international, and they even recognize its superiority. The problem is that this superiority over domestic law is mostly restricted to ordinary law and not to the constitutional law. Right? This is what the Italian courts call norma interposta. So international, even if it's superior to ordinary laws, it is still below the constitution. That's the general framework. In the US, the Lithuanian Constitutional Court recently held that the constitution, even though it's silent on the hierarchical position, it's superior to other laws, but not to the constitution. And this is the case in many countries. But there are some exceptions. So in Belgium, in 2004, the Supreme Court, that the European Convention on Human Rights has priority even over the Belgian constitution. And in the Netherlands, the constitution expressly authorizes the government to enter into treaties that are inconsistent with the constitution if it is approved by 2/3 majority in parliament. And the final example is the Article 2 of the Constitution of Bosnia and Herzegovina states the following: no amendment to this constitution may eliminate or diminish any of the rights and freedoms referred to in the European Convention on Human Rights. So there's an explicit provision that prioritizes international law over future constitutional amendments. I think I should say a special word about use cogens. So for example, in the Philippines, the Planas case in 1973, the court said that the sovereign people might amend the constitution in any way it chooses, so long as the change is not inconsistent with use cogens norms of international. And likewise in Switzerland, if you look at the current constitution, articles 193 and 194 state the following: in the case of total or partial revision of the constitution, mandatory provisions of international law must not be violated. So we have these limited cases of exceptions where use cogens norms are regarded by the either national constitution or the national court as prevailing even over the domestic constitution. So I have 4 minutes or 3 minutes left, so I want to end with a skeptic conclusion just to summarize the argument. There's a prima facie supremacy of international and supranational. That is correct, and it's obvious from the perspective of international. The problem is entering the internal espace juridique. We have this distinction between the external juridical space and the internal juridical space. And state practice does not demonstrate a general approval of international supremacy over the domestic constitution. Even if we have it, then it is the domestic constitutional law that determines the extent and limits of the effects of international supranational. So even in the Swiss case, for example, that gives priority to international law even over a total revision of the constitution, even over a new exercise of pouvoir constituant, of constituent power. But still, this is explicitly stated in the constitution. We can think of a new Swiss constitution that would say otherwise. Okay, so even when the constitution grants international a supraconstitutional status, such superiority derives not from international, unfortunately, as a separate legal order, but rather from the constitution itself. So this is a rather skeptic or pessimistic conclusion. Thank you very much, and I hope I was on time.
Thank you very much, Professor Roznai. Indeed, interesting thoughts, and I think Professor Venizelos now will share also his thoughts. In my opinion, what you said is very also close to the Greek legal order. There we had also the discussion there between the role of international law in the Greek constitution, where we have an explicit article, but at the same time we have the role of the European law, and whether European law is above the Greek constitution or not, and whether the Greek constitution should open the gates or not also to European law. But Professor Venizelos, of course, will share his thought as he's really the expert on this.
Thank you very much. Congratulations, dear Professor Roznai. I know your expertise. You are an excellent comparatist. You represent the new generation of comparative constitutional law in Europe, in Israel, and we share some common experiences, because also my habilitation 40 years ago was dedicated to the unamendability of the Greek constitution in 1944-43. But as you know better than me, the constitution, first of all, is a historical phenomenon, is a historical product, is the product of the correlation of forces. The correlation of forces is a very complicated issue, is factual and legal, legal domestically and internationally. We must make this combination. The constituent power is a historical procedure, is the perpetual incorporation of some legal steps toward the final product, the constitution, as the supreme law. A famous French jurist, main representative of positivism, Raymond Carré de Molberg, proposed a very useful distinction between the first constitution of every state and the other constitution through amendment, through total revision, or through a revolution, a radical change without limits of the domestic legal order. But the first constitution is very important for the statehood, for the national recognition and the participation of each state in the international community. From this point of view, we have in Greece a very long tradition of compliance with the international correlation of forces, because we know that finally we have the obligation to do it in order to protect the existence and the independence of the national, of the domestic legal orders. As I have a very long experience as the general rapporteur of the total revision of 2001, this is the existing constitution. We have two different methods to import the so-called international influence within the domestic constitution. The explicit solution through amendment. We have many important examples of compliance with the jurisprudence of the European Court of Human Rights and the Court of Justice of the European Union, especially on the field of the right to the fair trial, and also for the religious freedom. And the other solution is the so-called implicit solution through the interpretation of the Constitution according to the international law, according to the European Convention, or according to the European law, the European legal order. The famous example is the so-called presumption of the non-participation of a concessionaire in the so-called landscape of media in Greece. The transformation of the presumption of this incompatibility is the final result of a very difficult and long dialogue between the case law of the Supreme Administrative Court and the Court of Justice of the European Union. But the final result is the interpretative compliance of the Article 14 of the domestic constitution with a directive, not the treaty, a directive of the European Union in order to achieve the so-called coherence of the multiplicity of the legal order. This is the augmented constitution. The augmented constitution is the final product of this comprehensive procedure through the mutual respect between the different legal orders. I use a theological term in Greek, alleloperichorisi, mutual respect and mutual acceptance, in order to protect the coexistence of legal order. The other solution is to project the so-called objection of ultra-vires control, or the objection of the so-called national identity, national constitutional identity, according to the national conception, not according to the European conception. This is also a matter of correlation of forces, because for the European bodies, even for the Court of Justice for the European Union, is absolutely different to have an objection by the German Federal Constitutional Court, a totally different to have an objection from the Greek Supreme Court or from the Supreme Court of Cyprus. This is a fact. It's not a doctrinal approach, but this is a kind of sociology of the so-called parallel and simultaneous control on different level. From this point of view, the main issue is to elaborate a solution concerning the level of protection of democracy, of rule of law, and of human rights. If the intervention of the international law, if the objections of the UN Security Council, of the Venice Commission, of the Court of Strasbourg, of the Court of Luxembourg, is an intervention toward a major protection, we have the obligation to comply, to accept, to adopt this approach, to incorporate this approach in the interpretation of the domestic constitution through the interpretation in accordance with the international law and the European law. And this is the project of the augmented constitution. The other phase is the relativization of the domestic constitution. But the productive and positive phase is the augmentation of the domestic constitution in order to offer the best protection for democracy, rule of law, and human rights. And finally, the critical criterion, the final criterion, is the level of protection within the frame of a common legal culture, civilization, and order. From this point of view, the so-called internationalization of the domestic constitution has a kind of escalation. The most brutal phenomenon is the Japanese one, or the phenomenon of Cyprus, the brutal direct imposition of a new constitution from outside. The medium-sized intervention is a phenomenon like the North Macedonia constitution, the obligation to amend the domestic name and some dispositions concerning the national identity. The small size intervention the everyday size is the interpretation according to the international law and according to the EU law. This is my typology. This is my escalation. From this point of view, the final and existential problem is always the level of protection. And on the field of the so-called democratic constitution, the constitution of organs, is very difficult for everybody to understand this phenomenon. But on the other pillar, the pillar of the constitution of rights, of fundamental rights, this is something vital. Take note that I have a long experience from the Parliamentary Assembly of the Council of Europe as the rapporteur for the implementation of the judgments of the European Court of Human Rights. The Bosnia case is very important because in the name of the compliance with the case law of the Court of Strasbourg, we are before the possibility to deconstruct the Confederation of Bosnia and Herzegovina. The main value is to protect the peace, the stability, and the statehood of Bosnia and Herzegovina, not to comply with the case law of the court. And now, after the military invasion in Ukraine, we are one step before the destabilization of Balkan Peninsula. The next field will be Bosnia-Herzegovina, Kosovo, maybe Montenegro. And from this point of view, the main value is to protect the stability, the peace, and also the human rights for the wider population, not to implement a very concrete judgment of the Court of Human Rights from Strasbourg. By the way, the case law of the Greek Administrative Supreme Court concerning the compliance with the judgments of Strasbourg, and more specifically, the famous reopening of the trial after a judgment on violation, the so-called major premise of the reasoning is absolutely the same with the Russian one. What is the difference? The difference is, according to the terminology of Hans Kelsen, the legal culture, the acceptance of the force of the international law in general, not the concrete violation of or deviation, but the general acceptance of the general force of the international law. The same for the Constitution. From this point of view, as you know, Kelsen ignores absolutely the term unconstitutional. The problem was not the compliance, but the non-violation of the Constitution. And also the formal force, the formal power of the law is absolutely linked with the legislative procedure, not with the content. Because for Kelsen, the main issue was the power of the force of the legal order in general line. This is something very, very important for our discussion. This is my reaction.
Professor Venizelos, thank you very much for your thoughts. And before Professor Roznai maybe adds his thoughts to your statement, I have a question to what you said. You mentioned, and I think we can agree also with you on this, that we have some goals that are beyond law, like the stability, the preservation of peace. But my question is, as legal positivists, as person of law, how can we justify that we are going to set a judgment aside in order to preserve a goal that is not a strictly speaking legal goal, which is the preservation of peace, which is kind of political goal? How we can do it?
This is a very good question, because the international law especially is always a kind of laboratory of legal philosophy, of jurisprudence. From this point of view, I declare my position. I am a positivist. I am not naive. I am in position to understand the priorities. And also, I am in position to understand the historical values connected with the achievement of positivism. The legal positivism is a historical acquis, is not a formalism, is much more than the legal formalism. I am totally against the legal formalism. I am positivist, but including the values of the historical process of positivism.
I was going to answer the same thing to your remarks, because protecting, let's say, peace, etc., is not a non-positivist thing. If the convention or the laws themselves declare that one of the principles...
The principle of the UN Charter, the principle of the UN Charter.
So this is totally a positivist action.
Yes.
It is maybe not a formalistic one, but maybe, but it's still, it is within the boundaries of the legal order.
This is a problem of size, the size of the rule, the magnitude, the historical magnitude of the rule. But we talk always about a rule, the major rule, the principles of the Charter.
Maybe Professor Solomon, if I know we're already late.
Yes, Professor Roznai, you can offer your thoughts. And then we have also one question you see in the Q&A section.
You want to take the question of the Q&A first, and then I can maybe...
Yeah, the question returns us back to the previous discussion. It says, what will you recommend to reconstruct the new legal order in international law to get rid of such kind of losses like we're facing now? Maybe the case of Ukraine again. So maybe a brief answer of this, and then you can offer your thoughts and we can wrap up.
Perfect. Okay, so I'll start with the latter, actually. So at least for my narrow analysis, just for my presentation, it is true that eventually it is the domestic constitution that prevails, ultimately. That is true. Nonetheless, still, the use of explicit constitutional limitations, such as the one that appear in the Swiss constitution, that gives an explicit protection to international and human rights mechanisms, but do so explicitly in the constitution, still have a lot of value, both for the domestic incorporation, but also eventually to international protection. So at least my narrow constitutional recommendation would be still, well, I'll put it differently. The cure or the answer to international law is still the domestic constitution. We should use the domestic constitution as a tool to provide protection and enforcement to international rules and values. So it is still the domestic constitution that can provide extremely useful tools for the protection of international. Just maybe two remarks to Professor Venizelos' comments. Just briefly too, one of them deals with, he mentioned constitutional identity or the core identity. And here I want to say two things. First, it is interesting because I think that international law is part of the domestic constitutional identity. The constitutional identity is always a mixture, a battle between two disharmonic visions or values. One of them is the more particularistic national values, and the other one is the more universal values. And look at the Jewish, the Israeli constitution talks about Jewish and democratic, right? We have this harmony between the two conflicting values, and we see it everywhere. So I think that international always finds its way into the domestic constitutional identity. The problem is that, and here Professor Venizelos is right, we want to have a minimal core of protection. And so the German courts, when they first invoked this idea of constitutional identity vis-a-vis European integration, it was to give greater protection to human rights. They say, we want to make sure that the European law corresponds with our core protection of rights. We will not allow any violation of the core minimal protection of rights. The problem was that once other countries saw what the German courts did, for example, courts in Hungary and Poland, they say, oh, look at this is beautiful. We also want to protect our constitutional identity. But this was a misuse or abuse of constitutional identity to protect national values that are not fundamental rights or democracy, non-democratic values. That was the problem. So if we started with Tom Ginsburg and the misuse and abuse of international law, what we now see is misuse or abuse of constitutional identity as a term. I'll end here.
Yeah. If I may,
Yes,
first of all, the new generation of our discussion is the connection between the compliance with the international law or with the European law and some kind of sanctions. The interconnection between the compliance with the rule of law, with the non-disbursement of capitals from the new generation fund of the European Union. This is the case with the last judgment of the Court of Justice of the European Union concerning Poland and Hungary, before the invasion and before the war, because now we have new priorities. The priority is to reorganize West and reorganize EU as political entity. And Poland is absolutely ready to accept the mainstream. Hungary projects some objections. My second remark is about the famous problem of identity. Without doubt, they are two different concepts of constitutional identity. The so-called European one, according to the Article 4, Para 2 of the Treaty for the European Union, this is a European concept, and the Court of Justice of the European Union has the jurisdiction to interpret this clause. The other concept is a national one, is an objection concerning the supremacy, the primacy of the domestic constitution itself. This is the case of the famous judgment of the German constitutional law concerning the QE program, the APP program, the quantitative easing program of the European Union. But just after the publication, the issue of this judgment, we have the pandemic and a new huge program of quantitative easing, the PEPP. On the factual level, the judgment of the German court is absolutely null and void, because the economic situation and the common sharing of a new concept about the priorities and the needs of the European Union and the Eurozone is totally different after the pandemic and the economic crisis because of the pandemic. This is the interconnection between case law and political practice and economic needs and also economic emergencies, because we are always under the pressure of a perpetual crisis. And this is a new constitution and also a new international law, the international law and the domestic constitution of crisis. This is the problem, to incorporate this perpetual crisis as regularity within the international law, the European law, and also the domestic constitutional law.
So if I can say one more.
Yes, of course, Professor Roznai, you have to conclude, yes.
Yeah, and then I'll conclude. I just wanted to say something about the imposed constitution that Professor Venizelos remarked. So I'm not very much worried about externally imposed constitutions, for example, like in Japan, because if you look now at surveys, the Japanese people, they think they're of the constitution as their own, right? So, because to my mind, every constitution is imposed. It's only a matter of degree. It is either imposed by a majority on the minority or by a majority of an elite group on the rest of the country, or imposed by the judges through interpretation on the rest of the country. It's so that what matters to me is the extent of imposition, and more importantly, how rigid or flexible the constitution is, because even if it is an imposed, externally imposed constitution, if you can still quite easily amend it, then it's okay. I'm not so worried about that.
Thank you very much, Professor Roznai, for these thoughts. Professor Venizelos, for your permission also to conclude this discussion. We could continue for more minutes, if not hours, but eventually we have to wrap up the discussion. We thank also the audience for being here and posing interesting questions and listening to us. And to remind finally that the next event of the BUL International Law Group is on May the 9th. It's about digital evidence and international courts. With this, we close the event. We thank also Professor Ginsburg, who had to leave earlier, for his remarks and participation. And of course, Professors Venizelos and Roznai, who were here with us. Thank you very much. And a great evening.
All the best, all the best. Thank you. Thank you.
Thank you. Yeah, Harika.
Yeah, exactly.
Bye. Bye. Bye.